We have a special guest tonight that's I'm not even sure what all he's going to speak to you on. He's got a lot of information to share with you about constitutional issues and the law. So this is Barry Wayne Adams. Please give him your full attention.
Thank you. This is fairly important information. It dovetails into what you people are trying to accomplish here. What we're trying to show is how the existing government is not actually the factual, lawful government of the United States, but has... These are way bright in my eyes, so I'm going to have time. The existing government is what's called a de facto government, and that's different from a lawful government, or what's called a de jure government. De jure means of the law, and it means de jure government is the government that was originally designed by the forefathers by the implementation of the Constitution, the Northwest Ordinance, and other original organic documents in the country. What has transpired, especially since 1933, is that the country has essentially been sold out, sold to the realm of international finance and the World Bank International Monetary Fund. We were sold essentially as part of that bankruptcy. We are essentially chattel property to a faceless master, and this is something that, of course, your government doesn't want to really fess up to you about, but we're going to try to show you through some of the various symbols that they're using right now, especially as what's happening in the courtrooms, how, in fact, we do have a government that is actually our enemy. Now, you go into a courtroom, and right down here at the Battle Creek, what do they call it, Center for Justice, or some sort of corporate name. But in each of the courtrooms there, they will have a American flag, horizontal stripes, just as this, but with a gold fringe flag around, a gold fringe around the what's called the three strong sides of the flag. Now that has specific meaning, and although the issues concerning gold fringe are very volatile right now, and there's been a considerable amount of disinformation being put out right now, and we want to show you what we have so far, so you can try to make an assessment, because when it comes down to it, we have found enough to allow us to ask more questions, but not really to get any definitive answers. The only definitive answer that we do have is that the use of the gold fringe flag on the horizontal striped stars and stripes is a flag of the executive in his role as a commander-in-chief of the armed forces. Now, why is that being flown in a courtroom that's supposed to be a civilian courtroom? You're civilians. We're supposed to be not in a civil war. We're not supposed to be in an emergency power situation. But why are they used? This is essentially an emergency powers device, and the gold fringe flag is a symbol of the use of emergency powers by the president in his role as commander-in-chief. Why are they using this in the courtroom now? We're not supposed to be under the control of the military in this country. And I'll let Scott, why don't you read right up here. This is Article 1, Section 7 of the Michigan Constitution.
Really loud.
The military shall in all cases and at all times be in strict subordination to the civil power.
Okay. Now what does that say? That is Article 1, Section 7 of the Michigan Constitution of 1963. Now, this Constitution was put out during the time that there was emergency powers in effect. This was put out when, in fact, the military was in control and superordinate or over-controlling over the civil power, and that still is in effect today. And what we're finding with the use of the flag, we've been bringing in a lot of knowledge, a lot of extra information in the past few weeks. Before that, we had thought that the gold fringe flag meant that that was the war powers flag, and that the non-gold fringe flag was just the regular flag of the United States. Now, I have got a copy here of, and this is the most definitive resource that we've been able to find concerning the information about the flag, the most authoritative. This is from the Department of the Army. I got it right over here from Fort Custer, from the former commandant, a most reputable source. And this, I'll show it to Scott, and he can look at it just to verify it. That is Army Regulation 840-10, and that has to do with the Army's use of flags and other symbols, tabards, guidons, and other type symbols. This is the Army regulation. This is essentially the set of laws that the Army goes by in their use of the flag. And I'll read right from Chapter 1 here, where it talks about the purpose of the regulation. Now, what I'm reading here is essentially an enacting clause. Now, a little bit down the line, I'm going to be telling you about the importance of the enacting clauses and why the existing body of law in the state of Michigan and at the federal level, by the use of the statutory code, the United States Code, both of those are de facto void and null laws. They have no effect, and we'll be going into an explanation why that's true. And that will dovetail into the issues of the corporate United States that came and took over the lawful United States. Because essentially what the statutory codes are, both at the federal and the state level, are corporate representations of the lawful body of law. And when we buy into those, we're buying into the corporate government's jurisdiction over us. So these are the things we have to start looking at and understanding. A lot of the things that we do in our relationship with the court and our interaction with the law enforcement and judicial system ends up dovetailing out of our own ignorance, falling and playing into their ability to, through de facto measures, through not lawful measures, be able to bring you into their corporate type jurisdiction. Okay, now back to 840-10. I'll be reading, and this states the purpose. This is the enacting clause of this regulation, or essentially corporate law. The regulation prescribes the design, acquisition, display, and use of flags, weed-on streamers, automobile and aircraft plates, and tabards by the Department of the Army, organizations, and personnel. It's the authority for these items and their basis of issue. It also describes the flags used by the President, Vice President, officials of the Department of Defense, and Chairman of the staff. The important phrase in here is, it is the authority for these items and their basis of issue. That says that this is the law by what the Army goes by in their use of these symbols. So, explaining that, we go over to their description of the flag of the United States. Now, they talk about the flag of the United States as being the flag described in Title IV United States Code. Now, that's that statutory code that I'm referring to. That is the code of the corporate United States. Now, in doing that, they say that they are kind of in bed with this corporate United States. They say that they are kind of in bed with this corporate United States. So the description of the flag in 4 USC talks about this type of flag right here, essentially. The horizontal lines, 13 horizontal lines, with the blue field and the white stars. And this is the flag. I'll read here the authorization. The flag of the United States is the symbol of our nation. The Union, white stars on a field of blue, is the honor point of the flag. The union of the flag and the flag itself, when in company with other flags, is always given the honor position. For example, the marching flag, the flag's on right, or an observer's left facing the flag. The flag of the United States must always be of current design as described by Chapters 1 and 2, Title 4 United States Code, 4 USC Chapters 1 and 2. The U.S. flag will always be displayed or carried in ceremonies when any other flags are displayed or carried. Then we move down to the sizes and occasions for display. And it says the national flags listed below are for outdoor display, and it lists a series of different sizes of flags that go out, different types of federal, that are flown outdoors at different types of federal installations, forts, garrisons, and just different places like that. But it describes this flag. So this is the outdoor flag of the Army. Now, we go to section 2.3 down to paragraph B. And now we're getting into this stuff about the gold fringe. National flags listed below are for indoor display and for use in ceremonies and parades. For these purposes, the flag of the United States will be of rayon, banner cloth, or heavyweight nylon, trimmed on 3 sides with a golden yellow fringe 2.5 inches wide. It will be the same size or larger than other flags displayed or carried at the same time. So here we have a direct reference to the gold fringe flag as being a symbol of the Army and the executive. So we go to paragraph C now, authorization for indoor display. The flag of the United States is authorized for indoor display for each, and then it goes through several different categories, but we go down to here, category 4, military courtroom. So what this says is that when you see a courtroom, a court proceeding that has a gold fringe flag flying under it, or over it actually, this court proceeding is actually a military courtroom. Now this is something that was never supposed to happen in this country. It was one of the things that we fought about in the Revolution against King George because he was starting to implement these military-type courts, and it was so injurious to the life, liberty, and property of the individuals in the colonies that it forced them to rebel. So this is the most authoritative source that we have about the gold fringe flag. Now, in relation to what the flag is described by the Army is, we will describe that as the flag of war, the American flag of war. Now, there's a different American flag. There's an American flag of peace, and we're still trying to find out what the definitive, because we have a couple different sources that give a couple different descriptions as to what that American flag of peace is, but one of them says, and I'll let Scott read right up here. Now, this is from the Scarlet Letter, written back in 1850 by Nathaniel Hawthorne. You see what I'm talking about? Or is that the right page that I moved to?
Here with a view from windows?
No. We jumped pages. Thought I had it all ready to go. Here we go.
Okay, so from the loftiest point in its roof, during precisely 3.5 hours of each forenoon, floats or droops in breeze or calm the banner of the Republic. But with the 13 stripes turned vertically instead of horizontally, and thus indicating that a civil and not a military post of Uncle Sam's government is here established.
Okay, and that's enough of that. Now, this flag has been flying over forts and federal installations since the Civil War. There are indications here that say that there was a different kind of flag flying over the civil federal government prior to that time. Now, I was able to get some other resources, and there's also now this was from 1850. This was prior to the Civil War. Now, here's something that came out in 1926, and it says that this is the American flag of peace, and it's essentially that flag with a white border around the outside. But it says, but this is what it says, and I give limited credence to whether this is actually the American flag of peace. It says, at a meeting of representatives of the nations at The Hague, no universal peace flag was adopted, but it was agreed August 29, 1913, that each nation's flag of peace be its own flag surrounded by a white border. So this has limited credence. This has a little bit more credence, and what this says is that since the Civil War, we have been under a military de facto control of the nation. And when the hostilities were ended during the Civil War, the level of military control of the nation went from a level of martial law to a level of martial rule. And the difference there is being that in martial law, the military controls everything. You know, it's intimately controlling every aspect of what's going on in the nation, including aspects of business. When you move back down to martial rule, then the military butts out of everything except, or keeps its nose in everything except the realm of business and commercial activity. So this is the state we're at right now, and especially since all of the emergency war powers uses of emergency war powers by Roosevelt and the presidents after him in terms of licensing and regulation control of business and stuff like that, all of that power does not come from lawful civil authority, but comes from emergency war powers authority. It's not lawful for the government to butt into our private business dealings at any point. These are some of the things we're starting to see in terms of the information we're getting to determine what's really going on. Now, I've been in several different hearings in the courtrooms there, and I've been systematically penalized for bringing up these issues in front of a judge. They refuse to answer any of my questions directly, and I've got witnesses to that right in this room here. When you ask them direct questions about the nature of jurisdiction, what the meaning of the gold fringe flag in the courtroom is, and similar questions, they will just shut right up and then take action to shut you up. Now, you're supposed to be able to question the jurisdiction of the courtroom at any time. Now, I've just described to you how that gold fringe flag at Title 36A, Corpus Juris Secundum, in the section on flags, Section 6, Law of the Flag, it describes how the flag flying is a determinator of the method of contract that the master of the ship is using. The same kind of principle applies in a courtroom. The use of the flag, the type of the flag flying in the courtroom is the determinator of or is an indicator. It doesn't confer jurisdiction, but it is a symbol of the jurisdiction that is being employed in the courtroom. Gold fringe flag in the courtroom, meaning military court. Now, at 53 Federal Supplement at page 80, this is supposedly part of the civil case law, we have a case called McCune v. Kilpatrick. And it has to do with the direct issues of a civilian going into a military court. And I'll read from paragraph 4 right here. Civil courts may not surrender a civilian to the jurisdiction of the military for expediency, convenience, or even necessity, for to do so would destroy those constitutional rights and privileges guaranteed to citizens of this country. Also, civil courts should not surrender a civilian to the jurisdiction of the military in doubtful cases or in cases not clearly covered by words of the statute. So the only way a civilian can be brought into a military jurisdiction is by their own consent, and the only way to do that is through the use of a contract. The existing courts are operating under a jurisdiction that they don't want to tell you the direct name of it, but the best we can determine is that it's called a statutory jurisdiction based on the use of this corporate statutory law. And their methodology is to try to get you, and usually through the use of your lack of knowledge about the laws of contract, to get you to enter into contracts and get your signature down on there. And when you do that and sign these contracts in a manner that doesn't protect yourself, say by failing to qualify it all rights reserved or without prejudice or other similar qualifications of signature on these contracts, then that allows them to have jurisdiction over you and just start messing with you. Take corporate control of your life, usurp your property, your liberty, your family relations, whatever they want to do.
The inspector can come in your house.
Exactly. And see, that's what we have to worry about when you're talking about that, is that we shouldn't have to go back and start making new laws that assure us things that we're supposedly that are already our rights. Now, Fourth Amendment says that they can't come in any way, shape, or form unless they have a valid search warrant based on probable cause, and they're looking, for something definitive, pursuant to the obligations put on them through the Constitution. When it comes down to it, it's really your business what kind of domicile you want to live with, and in a common law world, you're allowed to live in your own filth, just as long as it doesn't impinge on anybody else's life, liberty, or property. So if you want to live in a shack made out of pallets and flattened out Coke cans, that's your business. When it comes down to the direct rights bestowed by the common law. So we're trying to establish that, in fact, we have military control by the use of the military courts, that the military is in fact in control of us, and in doing so, it is a de facto government. De facto government means it exists in fact, but it does not exist lawfully. It's been taken by what's called usurpation, by the unlawful or mischievous, deceitful, whatever methods can be used to pull away your rights. Now, all this has been done by the use of very complex legal codes, other statutory devices, and the uses of committees, the uses of corporate government as opposed to lawful participatory government. All of these methods have been used to slowly, little by little, take all your rights away, and really all you have is all your debt obligations. So this is essentially what the use of this corporate government was to transfer the debt that was incurred by the agreements made by the politicians and the statesmen back during World War II and a little after, how to defer those debts slowly down so you have to end up taking individual responsibility for them. And this is going to come down much harder in the near future. I don't know if you're how much you know about the use of the change in the money since 1913 with the Federal Reserve and all those devices which changed this was one of the other devices used to convert from a lawful government to a de facto system, was to move into the realm of commercial paper, where you don't have legal money anymore. All the gold and silver was taken away, actually stolen from the people. This was an act of theft. People back in 1933, the Gold Standards Act, or I don't recall the exact name of it. Yeah, the raw deal. But this has been going on. The slow, gradualistic deprivation of your individual sovereign rights, your right to control absolutely your own productivity, your own destiny, that has been taken away from you, and pretty much your life is very structured, very much dependent on your ability to get a paycheck, your attachment to the Federal Reserve note, and all the other debt obligations that you had to incur just in order to be able to live out your life, to fulfill your creature requirements. So things have been going on even all the way back to the Civil War, and even all the way back to the beginning of the country, that show that there has been these little inserts of legalistic trickery that have been used all the way down the line to slowly usurp the lawful government away from the people. Now, I'm going to read from Cohen's v. Virginia here, and what we're talking about here, what happened in the Constitution? There were two governments actually created. One was the lawful federal government that was supposed to have control and authority over the activities of the states, and the other, at the same time, was the corporate United States government, which was supposed to be control over the 10-mile square area of Washington, D.C. Those two governments were formed at the same time, and they were under the auspices of the same Congress. And even back in 1821, when the justices started seeing how this device was being used, they started sensing what was going on and put little zingers in their judgments and their case law that showed that they were beginning to understand the trickery that was involved in creating this parallel system of government, two governments, and then down the line discarding one and having the other being the hidden replacement. I'll start reading from here. Wherever a question arises whether a law passed by Congress is a law of the United States, we have only to inquire whether it is constitutionally passed in execution of any of the federal powers. If it be, it is properly a law of the United States, since the federal powers are coextensive with the limits of the United States, and this, though the particular set may be confined to certain persons, places, or things. Thus, a law establishing federal courts in a particular state is a law of the United States. For its immediate operation is upon one state, yet it is in the execution of a power coextensive with the United States. But if a law, though passed by Congress, be passed in execution of a municipal power, as a law to pave the streets of Washington, then it cannot, in any propriety of language, be called a law of the United States. It is an axiom in politics that legislative power has no operation beyond the territorial limits under its authority. I do not now speak of the doctrine of the lex loci, that's the local law, of that comity by which the different states of the civilized world receive the laws of others as governing in certain cases of contract or questions of a civil nature. I speak of the intrinsic energy of the legislative power, its operation per se.
What was the site
That was that's Cowansville, Virginia, 5 LED 257, and that's at 264. Now, they were seeing back, all the way back at the beginning of, this was 50 years after the beginning of the country. They were starting to see how there were being devious and mischievous changes in how the Congress, the use of the Congress was being employed in Washington, D.C. And what finally happened down into 1933, and after FDR essentially ended the lawful government, started the de facto government, the corporate United States government, and that municipal power government that they were referring to in here took over the control of the whole United States. Now, it could only have been accomplished by having created a law, which a supposed law, which gave authority of the United States, that corporate United States, over your person, and that was done by the use of the 14th Amendment, and that was done back during the Civil War. And it almost seems like the use of military emergency powers during the Civil War in the creation of the 14th Amendment was more important, agenda-wise, than the actual abolition of slavery, which was the purported reason for the whole Civil War. The Southern states did not want to become did not want to go under the corporate control of the United States, and they did not want to enter into the creation of the 14th Amendment, and actually went through and vetoed the resolutions to create to ratify the 14th Amendment by the states. The 14th Amendment is the one that that says that we are all inhabitants and citizens of the United States, as well as citizens of our own state. Now, what they're not fully explaining in there is that's the corporate United States, and what it does is creates a dual citizenship. Now, the Southern states refused to ratify, so the Civil War was created. The North went down and created went down into this same kind of de facto military war powers activity, dissolved the lawful governments in the Southern states, went down and artificially ratified the 14th Amendment, and then they went back, in a few years later, came back and reestablished, supposedly, the reunification of all the states. But it did not return back to lawful civil government when that happened. It went to a reduced martial rule scenario. So this is pretty much where we're at right now. So we're entitled to we're entitled to a civil government. That's what our Constitution says. That's the contract between the government and us. And so what sort of device can we use to try to implement that? Well, this is one of the things we've been trying to mull over, trying to get strategies to use in a courtroom, and it seems we're starting to get somewhere, especially when you go into a courtroom, you should be able to challenge the jurisdiction using this McCune v. Kilpatrick, and I'll read from paragraph 1 here. A person subject to military law and the party asserting military jurisdiction over him has the burden of proving such jurisdiction and must point to a valid federal statute that confers it. Now, these courts tell us to come down. We blindly come down, walk right across the bar, walk into their jurisdiction, give our name to them. That confers jurisdiction over us. We never question that. We're starting to see that we do have the devices to go in and actually, from the very beginning, question their ability to have jurisdiction over us. Now, what this says is that this puts the burden of proof on the prosecutor to prove that you, as a civilian, are obliged to enter into a military jurisdiction. Now, this is just one of the devices that we're using. But the overarching point is their devices, their use of de facto laws and statutes are a fraud. There's been no real reason for us to not return to a civil lawful government, although all the presidents all the way down the line have continually found reasons to keep continuing the martial rule, the emergency war powers scenario going. And I just saw something that was from the National Register within the last year that again Clinton reestablished his emergency war powers authority over us because of the fact that there's still nuclear weapons in the world. So they have, in fact, with this emergency war powers scenario, decided to, in fact, all the way back to 1933 that we've been able to find, we've been able to determine that through 12 U.S.C. 95B, which says, let me find it here. The essence of it is that, here we go. The actions, regulations, rules, licenses, orders, and proclamation heretofore or hereafter taken. That's the important part. They're giving, this is a validation to give authority for all the executive orders that they want to do down the line as far as they want to do. The actions, regulations, rules, licenses, orders, and proclamations heretofore or hereafter taken, promulgated, made, or issued by the President or of the United States or the Secretary of the Treasury. That's another important point of this de facto corporate government. The Secretary of the Treasury has been given equivalent martial rule or emergency war powers authority, equivalent authority to the President, pursuant to authority conferred by subsection 6 of Section 5 of the Act of October 6, 1917, as amended. That's 12 U.S.C. 95A, are hereby approved and confirmed. Now, this subsection, Section 5 of the Act of Authority conferred, or October 6, 1917, 12 U.S.C. 95A, is the Trading with the Enemy Act. That was put out in 1917, and it was the beginning of the implementation, and by seeing what actually happened all the way down the line, you'll be able to see how these devices are used. In 1917, beginning of World War I, the government felt that it had to have authority over anyone that was affiliated with the enemy at the time, the Axis powers, and they enacted this law, Trading with the Enemy Act, and what it said, it gave the President the authority to license, set licenses, regulations, rules, and permits, any kind of economic or commercial authority over anybody affiliated or involved in interaction with the enemy. So that stayed, 1917, and at the time, oh, well, fine, yes, we want to have the President making sure that, the enemy isn't supplied by our businesses and that kind of stuff. So fine, then we go through World War I and then move into World War II, into the scenario preceding World War II, with the Depression and the subsequent taking of the gold, which was the big theft on the American people by FDR. And then we move into the Emergency War Powers Act, and they amend the essential part of that Trading with the Enemy Act 1917 was that it wasn't for people in the United States. It was for everybody else except people of the United States, citizens of the United States. Now we go to 1933, Emergency War Powers Act. They amend this Trading with the Enemy Act to include both people outside of the jurisdiction of the United States and people inside of the jurisdiction. So it included us. So essentially what happened at that time was that the government of the United States, the corporate military government, declared war on us, declared us as their enemy. So this is essentially what is happening right now. The government went bust, turned into a corporation. It's now essentially a collection agency, so to speak. Their effort right now is to try to maximize the amount of productivity of the individual workers in this country and try to minimize the amount of that real gain that we get to keep. It's just a method of creating wealth and shipping it off someplace else, pursuant to some bad business dealings that none of you have ever put your signature on a contract to. Now that's where the fraud is, and they keep perpetrating it. So we're trying to find a device to use in a courtroom to be able to bring it back on these officials. All of these people, especially as you get higher up the ladder, the more they know about what's going on. You know, when I talk to judges and stuff like this, they shut right up, and their reactions pretty much confer that we're talking the same language. But the people down the line don't really know what's going on, and they think they can just do whatever they're doing, carte blanche, without any consequences. So what we've been finding in the law library, trying to research this out, try to find some sort of remedy, how each and every one of us can come back and take redress to our government about this stuff. We seem to be finding some potential in Title 37 of American jurisprudence that deals with fraud and deceit. And what has happened is that they have frauded us out of our inalienable rights and individual properties, our property and liberty interest, which is part of our personal entitlements, part of our personal property. They've deceived us out of our property. Now, when the components, the elements of a fraud suit are deception and somebody benefited from it. Somebody benefited by deceiving somebody. They got the person into either giving up their property or giving up their rights, giving up some sort of essential liberty or property interest that the individual has. This is what they've done. They've frauded us away from our rights, and they do it under the guise of procedurality, use of documents. But if you know your law of contract and the fact that if your name isn't on something, you're not liable to it, that's an empowerment. These are the things. If you're going to try to tackle some of these issues in a legal arena, you have to start learning about this stuff. You got to know your law of contract up and down, because these military courts operate on the creation of fraudulent contracts, and you have to know how to be able to thwart their attempt at creating contract with you. The only way that we can get past this is by knowledge. The only way that we were able to, at the beginning of this country, the only way that we were able to get away from having total subjugation of us was because people like Washington, Jefferson, Adams spent the time to learn about this stuff, to learn how egregious of a injury it was on the common populace, and to learn using the tools of intellectual devices and abstractions and legalisms to be able to explain away or to point out the essential fraud or deceptive actions of these peoples. So this is what we're trying to show. We've got a fraudulent government going here. We've got books like De Facto Government by Charles Weissman. This guy's been writing some real good books. He also wrote a book on arrest and false imprisonment, which shows that the methodology that they use to arrest. I was just falsely arrested last Monday. Marshall Police Department. They claim that they have a warrant for my arrest. I ask them for it. They pull a piece of paper off a computer that says, "Oh, this says that there's a warrant in the computer." Well, and they proceeded to arrest me. Well, that's not good enough. And because we don't know our due process, they managed to get away from it. Well, I'm going to be suing these guys who arrested me because I know that because I know the elements of a valid due process arrest. And they didn't show me a valid warrant, and you just can't arrest somebody without a police officer cannot arrest a person unless directly. He can't arrest a person directly without warrant unless he views them involved in an act of the breach of the peace. If the person is not engaged in an act of the breach of the peace, he has to have a lawful, valid warrant to arrest him with. And they just think they can just walk in and I can arrest you and let's go. And no, it has to go by due process, and the officers become liable when they don't follow that. So this kind of stuff is happening all the time, and we don't know what the rules of due process are. We just go and go to a lawyer, and they tell us what to do, and we do it, pay the money, go back home. Hopefully, we'll be let off. If the judge doesn't like us, he'll mess with us a little more. But there's nothing that resembles a lawful common law type jurisdiction judicial system anymore. We're entitled to a common law judicial system. Article 3, Section 2 of the U.S. Constitution specifically says that the judicial power extends to all cases arising under law, equity, and admiralty maritime. Now that's all cases. That's not only some of the cases, and then we can shove some of the other cases into an administrative court or a legislative court or a military court. Also, in Marbury v. Madison, this also is talks about the power of the court, the court's authority over a person. Very simple statement, but very important. The judicial power of the United States is extended to all cases arising under the Constitution. In a military court, they're not operating under the Constitution. They're operating according to what's called the doctrine of necessity, which means that they can do whatever they want in order to accomplish their ends. In a military court, the judge is not an impartial referee. The judge is in cahoots with the prosecuting attorney. In a military court, the equivalent of the prosecuting attorney is called the judge advocate, and the judge and the judge advocate work in cahoots against the defendant to prosecute them. And this is exactly what's going on. I've been purposefully defrauded by the devices of the prosecuting attorneys, while the judge just stands there and watches it happen. And doesn't makes no things that are obviously fraudulent, obviously against due process, obviously violative of my rights, but the judge will just let it happen because it's part of the show. Also, in this Cohen's v. Virginia, it supports the notion that the lawful courts are only able to operate under the three types of jurisdiction: common law, equity law, and admiralty maritime. And right here at 404, Cohen's v. Virginia, we have no more right to decline the exercise of jurisdiction which is given than to usurp that which is not given. The one or the other would be treason to the Constitution. That's a very important statement. This is one of the this Cohen's v. Virginia is one of the real resources that we're using right now, because what it says right here is that these courts and the manner in which they're being used over the average person is treasonous. So this is what we need to do we need to start getting actions of treason against these people in the judicial system. Now, how are we going to do that? We're going to have you're going to be able to go down to a lawyer and say, I want to put down a $500 retainer and get a action of treason against the judge. No, it's not going to happen like that at all. You're going to have to spend time going to the law library. You're going to have to make the effort to put in a complaint on your own. You're going to have to do some study in the law. Things aren't going to change until, there is going to be a change, and it's going to happen either two ways. One, it's either going to be done by exposing the fraud, turning on the light, and letting the cockroaches run away, or it's going to get real bloody and with a lot of bullets. Now, they specifically want you to start pulling out your guns and start shooting. And in doing that, you're playing absolutely into their hands and into their agenda. They want you to get violent. They want you to start using the guns. They want to be able to come out with overt martial law. This is by taking the approach of exposing the fraud, getting this information out, disseminating it as much as possible to people. Everybody has to know about this stuff. They have to know about how they've been defrauded, how their lives have been sold down the river by decisions that were made decades ago that you never put your signature to a contract on. Now, that's a fraud. You have unlimited right to contract. You are involved in contracts that you don't know about, and you were being defrauded about it by lack of notice to you. Now, let me start talking a little bit about what I was discussing about before with the corporate United States and how that is evidenced in the use of the statutory codes. Now, we're going to the Michigan Constitution again, and Article 4, why don't you read Section 23 and 24? Okay, this will only take about 5 minutes.
Section 23 states the style of the laws shall be the people of the state of Michigan enact. Section 24, no law shall embrace more than one object, which shall be expressed in its title. No bill shall be altered or amended in its passage through either house so as to change its original purpose as determined by its total content and not alone by its title.
Okay, so what that says is that every lawful law in this country has to have a little blurb with it that says that the people of the state of Michigan enact. And that's supposed to be between the title of the law, which describes what the law is about, and then between that and the copy of the law, which goes into much more detailed explanation of what the law is about. Each one of those is supposed to have what's called an enacting clause in there, and if it doesn't have it, it's not a valid law. These statutory codes, the Michigan Statutes Annotated, Michigan compiled laws, all of these corporate bodies of laws are part of the de facto government. Our lawful government publishes its laws at the state level. They're called public laws, and at the federal level, they're called statutes at large or public acts. Those are the lawful laws of the country. Now, there were committees of legal revisioners who went through during the mid-20s, went through and created recompilations of the laws, revisions of the laws, and categorized them in a certain way, and end up generating these United States Service Code, Michigan compiled laws, Michigan Statutes Annotated, etc. These are not lawful laws of the United States, although these are the laws that the police and the courts are using to incriminate and prosecute you with. None of these laws have the enacting clauses as described, as what Scott just described in the Michigan Constitution. They took them out. They only some of the laws that are included into these statutory codes contain an enacting clause, and most of them don't. So everyone that doesn't have, there's case law, People v. Dettenthaler, and luckily enough, that's a Michigan case law. And it goes into the issues of the necessity, the mandatory necessity, and they call it mandatory. The Supreme Court of Michigan has said that it's mandatory to have these enacting clauses, and it's not merely directory. It's not merely something that should be on there. If it doesn't have an enacting clause on it, it's null and void. It is no law. And this is what everybody is being prosecuted and incriminated with, all this statute law. The statute law is part of the de facto government, and it's just a continuation of the fraud. Now, the use of, we appear to have an operating civil government, don't we? We have a Congress that meets, and courts that convene, and all this kind of stuff. Well, isn't this a civil government? Well, no. The legislature actually operates as part of the de facto government, and that is, the evidence of that is in their use of the HR, the House resolution, as opposed to the just plain H, which is the House bill. Resolutions are merely advisory documents, opinions that are sent to the executive in the executive's dispensation of his emergency war powers tasks. Whenever you see those HRs, those House resolutions, it means that we're under emergency war powers. Look for this in the newspapers. Look for, when you see that the House has done something, it will be in the form of HR or SRs, Senate resolution. Also, when either the governor or the president acts, it's in the form of an executive order. An executive order is a device of emergency war powers. He should be passing laws and signing bills, passing bills into law. That's what a civil government does. But every time we see the thing, executive order coming through the pipe, it's a revalidation that we're still in an emergency war powers scenario. So unless you know what's really going on, unless you've really been tuned in as to how the government is being employed, it has the full appearance of being just the regular civil government that we learned about in civics class back in high school. But actually, it's not. Again, the use of executive orders and the use of resolutions by the legislature.
They just passed Resolution 230 along with Simon DA.
Right. And with that Sine Die issue, the importance of that is that they were planning to shut down the government cold. And why would they want to do something like that? They want to shut down the government cold because these guys are scared up there. They know that that they're also coming to the edge of a cliff, and they don't know where to go after that. A lot of things are happening right now. Their house of cards is starting to collapse, and we're starting to find out what the real score is about how we've been deceived and how we've been sold down the line. Hopefully, these will all work together in a harmonious manner rather than a disharmonious manner. Yeah. So rather than I could go into other things. Do you understand what I was saying about the statutory codes and how they don't have the enacting clauses, and in doing so, you're operating under essentially a non-constitutional form of government?
Statutes is how King George III was really an American.
Yes. Yes. Laws, especially in terms of laws, felony laws and things like that, were supposed to be things that were called, in a legal sense, called malum in se, which were things that were that had evil in itself. And there's no question that we should have a law against murder, have a law against rape, have a law against robbery, have a law against real common law injuries to real people. You know, we've got no qualms about that. And that was supposed to be the extent of the use of a crime law, a high crime law against an individual. Now, when you have a law like speeding, where you maybe go 5 miles over, 10 miles over the speed limit, you don't run into anything, you don't hurt anybody, but you still get pulled over and and the state claims damages against you for an injury against the state. Now that's called malum prohibitum, and that's opposed to malum and se is things that are evil in themselves. Malum prohibitum are things that are made evil by the passing of a law, things that are made law just by decree. And this is where we were never supposed to fall into in America. We were never supposed to fall into the use of statutes, the use of malum prohibitum type legislation, where the state can just start coming around and saying, well, we decide that this is wrong now. So where nobody's really injured. You all can find plenty of instances of how this type of statutory authority is used, where there's no real injury to any real person, but the state claims that there's been some sort of injury against them. That is the essence of a statutory code, and that's why it really can't be enacted into a de jure law, because it still has the attributes of the malum prohibitum statutory aspect. Statutory law is municipal law. Municipal law is military law. They've been planning on implementing this change from a lawful government into this hidden military control type government. This has been going on since the beginning of the state of Michigan. In the Constitution of the Constitution of 1850 of Michigan. The first Constitution of Michigan says that in the section about the judicial department, it says that the Supreme Court has the power to create inferior courts. Well, that's fine. We want one Supreme Court, and we want to have some inferior courts that are able to help adjudicate our individual dealings. We go to the Constitution of 1850. It starts saying, well, these inferior courts, we can also create what are called municipal courts. Now, that sounds fine ostensibly. Municipal, we equate that word with being related to city. But actually, municipal means a venue of jurisdiction that is unto itself. That does not. So a municipal jurisdiction is one that is not obliged to abide by the Constitution. That's the use of that term, municipal. Also, at the same time, I think it was the Constitution of 1850. There was in the judicial department a mandate to the legislature to begin legislating without a distinction between law and equity. Now, the creation of the statutory jurisdiction was done by the use of what's called the abolishing of law and equity. Let me find that. It's Article 6, Section 5. And now, listen to how innocuous and harmless this sounds.
Section 5, the Supreme Court shall by general rules establish, modify, amend, and simplify the practice and procedure in all courts of the state. The distinctions between law and equity proceedings shall, as far as practicable, be abolished. The office of, as far as practicable, yeah. The office of master in chancery is prohibited.
Okay. Who knows what that means? A lot of legal mumbo jumbo. When they start abolishing at Article 3, Section 2 again, law and equity were supposed to be separate jurisdictions. And the rights of the individual are optimized when those jurisdictions are being employed separately. It means that the state can't enter into phony contracts. It can't start making its own claims against you. Common law jurisdiction has to deal with real injuries to real people, which are essentially violations of the social contract when a person goes and violates somebody else's life, liberty, or property. Equity law has to deal with contracts, law of business. So you have to have a contract with two real people signing conditions of contract, and at that signing, that is the contract. You can't add anything down the line. You can't pull anything under the table that says that, oh, by the way, there are more conditions. Equity law has to deals with the law of contract and business aspects of business. Admiralty Maritime is an international jurisdiction and has military overtones. It is a law of contract, but it has in equity law, the difference between Admiralty Maritime and equity. Equity is a jurisdiction of contract, but it can only compel performance. It can only tell you if you signed a business contract. It can compel you to fulfill the contract that you signed, but it can't put you in jail for anything. Because there's no. It's essentially they're essentially civil procedures. Admiralty Maritime is a law of contract, but they can't put criminal punishments on you. They can put you in jail for not fulfilling your contract, that's an equivalent type of jurisdiction is what's being used in these military courts. They bring you into contracts, putting you under certain performance obligations. If you don't fulfill those performance obligations, they throw you in jail. That wasn't supposed to happen in this country. Now, by abolishing the distinctions between law and equity, they've created a new method of jurisdiction. And why don't you read this little blurb here at Section 26, Article 6, Section 26, right here.
Present statutory courts. Statutory courts in existence at this time this Constitution becomes effective shall retain their powers and jurisdiction except as provided by law until they are abolished by law.
Okay. Doesn't sound like much, does it? They admit that these courts exist. They admit that these statutory courts exist, and in a certain way, by giving provision for them to be abolished, and abolish is a pretty severe measure, that they aren't part of the lawful government. They give them authority to exist at the moment, but they say that down the line they should be gotten rid of, essentially. In the Constitution of Iowa, it even has a provision in there that says that law and equity will always remain separate and distinct. That was there have been many different provisions that have been used in the various state constitutions to hinder the utilization of military courts on the civilians. Down in West Virginia, Article 3, Section 10 of their Constitution specifically prohibits bringing a civilian into a military court. And by abolishing, they use different terminologies, uniting, merging, abolishing the distinction, the elimination of common law, many different ways of describing it, but they end up creating this statutory jurisdiction, which is the de facto military corporate jurisdiction, treating you as owned chattel. Okay.
Another question?
Yeah, more questions.
Well, if the Constitution is so clear that there are only 3 kinds of law allowed, and hopefully lawyers, judges, policemen have an appreciation for this oath they've taken, and yet Cohen's v. Virginia suggests that if you don't follow those laws, the 3 jurisdictions, if you go outside of those,
It's treason.
akin to treason. Don't these people have an obligation to protect us from enemies, foreign and domestic?
That's right.
Doesn't that make policemen and judges?
And this is where our ability to take action against them in the courtroom stands. And each of these people have taken an oath of office. That oath of office puts them is a statement of performance obligation when they took these on these fiduciary obligations, these the obligations of public office, they took an oath to uphold and support the Constitution of the United States. They are, in fact, and I hope I've described enough to you here to show to you definitively that these people are absolutely not living up to their oath of office by playing out these statutory court scenarios. In fact, they are doing absolutely, they are aiding and abetting the enemy because they have in fact declared us as enemies to them. They are aiding and abetting the enemy and are in fact operating under treasonous pretenses.
A while ago, we passed out, somebody was mentioning earlier, documents in this county trying to inform the elected officials of just what you've been describing. And some of you might remember that we passed out that document all over the state of Michigan, and especially here in Calhoun County to about 30-some of our elected officials here in Calhoun County. And that was the object, was to describe to them the state of operations of our country and that we're not operating under the Constitution at this time. And so they didn't understand what we were doing at that time because we kind of hit them with all this at once. They didn't get the background information that you've gotten here on this. So they weren't able to understand that document as well as we do. But that's what we were doing, is serving them with notice that they've been operating unconstitutionally all this time.
And, oh, yes.
Has there been any judge, lawyer, or police officer been brought up on charges of treason as yet? And
Not yet. We haven't seen any of that happen yet, only because most of this stuff, I've been connected with some of these, self-representing people in the state for a couple of years now, and most of the activity has been pretty much involved in the game playing within the jurisdiction and kind of validating their jurisdiction. But as this stuff has just been coming out as we've been doing more research, there have been actions taken against individual judges, but they've been taken against the judges for their individual injurious acts on the person.
Utilizing Title 42s.
Yeah, using 42 USC 1983.
Basically similar to suing a judge or...
Yeah, and within Title 42 and within Title 18, Section 241 and 242, there are remedies ostensibly given by the corporate United States to challenge these judges. But in the actual ability to prosecute these things all the way through, we're finding that the guys up at the federal level are kind of in cahoots with the whole scenario too. So it's got to be a twofold thing here. I mean, we can spend our time individually going into the courtrooms and trying to expose this stuff in a court file, which nobody ever sees. But none of this is ever going to happen until the people at large know what's been perpetrated on them, and there is enough of an effort, enough pressure to get these people to clean up their act. Anything else? Yeah.
how do we actually go about, what's the method to get out from under this emergency power?
Yes, he was asking about if there's any sort of method. I've alluded, not in great detail, to some of this stuff, but again, in that Title 37 American jurisprudence dealing with fraud and deceit, we have found that they have defrauded us away from our rights. Now, they have